Um, a very good morning to everyone that's joining us this morning for our webinar on AI on trial, where we'll be discussing the legal risks that are attendant to this emerging technology. My name is Shem Otanga. I am a partner in CDH's Nairobi office. I specialize in intellectual property law, data privacy, and telecoms advisory work. I'll be playing the dual role of moderating today's discussion and also sharing some insights as well on the topical issues that we'll be discussing. With me, I have on today's panel, I've got Miss Doreen Ochodo, an advocate of the High Court of Kenya with a background in corporate in-house practice, focusing on telecoms and technology law. She works at Safaricom PLC, the largest telco in Kenya, telco and technology company in Kenya, and she's a part of the customer privacy team, where she supports the business to embed privacy by designing all their products and processes, and guides privacy and data protection awareness and policy implementation within that organization. In that capacity, she's been involved in the development of the company's AI governance framework, through which a roadmap has been established for the ethical and responsible creation and adoption of tools to operationalize the practical use cases for AI within Safaricom. So her insights will be more than invaluable for purposes of today's discussion. A very warm welcome to you, Doreen. Also with us today is Ms. Taiba Suleiman. She's a seasoned legal practitioner with 15 years of experience in managing complex TMT transactions, data protection work, as well as M&A work for clients across multiple jurisdictions. She's engaged extensively with regulatory authorities across Africa, and she's also provided strategic policy, compliance, and risk advice to clients. She's the head of CDH's Tech and Communications sector, and she joins us live from the City of Gold, Johannesburg, South Africa. So a very warm welcome to you, Taiba. We are pleased and delighted to have you as part of today's panel. Also joining us is my colleague from the Nairobi office, Daniel Kiragu. He's a senior associate in our dispute resolution practice. He's got over 7 years of experience in successfully advising and representing both local and international clients in a wide array of groundbreaking contentious and non-contentious matters. His main area of expertise is commercial litigation, ADR, insolvency banking, employment and labor law, and he'll be chiming in with some insightful views on the legal risks and liabilities that arise in the AI and tech ecosystem. Daniel, we're pleased to have you. A very warm welcome to you as well. Now, I'll be wearing, as I kind of alluded, the dual hat, carrying the dual roles of moderating, but also offering insights in this discussion as we go along. And just to set us off, I'd like to talk a little bit about the risks that arise in the context of intellectual property, right, as far as the use and development of AI tools is concerned. And starting off perhaps from a copyright perspective, I guess the foundational premise is that copyright by its very nature restricts the doing of certain acts with respect to protected works, one of which is the reproduction of such works. AI by itself tends to be developed and trained through data sets, but particularly generative AI, data sets from which it learns patterns and from which algorithms are derived, and it then develops a capacity for generating new content. Now, the feeding of these massive volumes of data for purposes of training AI models would invariably involve the reproduction of literary and other forms of work that may be the subject of copyright protection. Now, to the extent that such reproduction occurs, right, there may be a risk of copyright infringement, right, of the rights that are held by the owners of the copyright protected works. The question then arises, do you need a license in order to reproduce the massive data sets that are used for training AI models? Or is there an applicable exception that you can rely on in the training of these AI models? Now, a lot of copyright laws provide for fair dealing and fair use, and in some jurisdictions we've seen this exemption being relied upon, where it's for purposes of scientific research or private use or criticism or review or the like. The dealing of such copyright protected works in the training of AI models then is not tantamount to copyright infringement. An emerging line of thought that is, and it's not been tested in every jurisdiction, but it's beginning to emerge, that fair dealing and fair use can be relied upon as an exemption that allows a training of AI models. In other jurisdictions, we're seeing specific laws being passed with specific exemptions for the use of copyright protected material for the purpose of training AI tools. So it's a statutory permission essentially for developers of these tools to use copyright protected data to a certain extent to train their AI models. Now, the question as to whether there's a risk that the output of particularly generative AI models being infringing of the copyright interests of others is an interesting one, right? Some tests have shown, some research has emerged and has shown that, up to 44%, for example, of the content provided by OpenAI's ChatGPT, contains copyrighted material, right? Mistral AI, a French company, was tested along the same lines, and 22% of the content that was generated by their AI platform was found to contain copyrighted material. So what happens then when you rely on these outputs for your own purposes as a business, whether it's in creation of your reports, whether it's in the publication of material, a risk of copyright infringement becomes very real and very material, right? From a common law perspective, for copyright infringement to arise, there needs to be a substantial copying of the previous work in qualitative terms for the threshold for copyright infringement to be crossed. And so while this is a very real risk, it's something still that might not necessarily occur in every case, though it could occur in certain cases, as I've demonstrated from the statistics that I've just shared a moment ago. So how do you guard against this? How do you guard against the risk of relying on generated content that has copyrighted material? Well, to put it in very simple terms, you need to review the output. The content has to be critically reviewed to guard against this risk. And there are tools that have been developed for this purpose to help detect the use of copyrighted material in the outputs of Gen AI models. You've got Originality AI as an example, No Plagio. Some of these are used to review theses that people publish or submit, in the academia and so on. And they can be deployed in other scenarios in the course of business as well. Another thing that can be done is to train the users of generative AI within your businesses on how to use these tools. So when they're giving prompts to these tools, are the prompts well thought out? Are they creative? The prompts must not direct the AI tools, for example, to create updates of pre-existing work that may be the subject of the rights of third-party right holders, right? So those are some of the things that can be relied upon to mitigate against the risks that arise in the copyright context. Now, as far as ownership is concerned, who owns the output of an AI, a generative AI model? Will the generative AI service provider own it? Will you provide it as the person who provided the prompt to the AI tool? Typically, the terms of use of these AI models would have something to say about that. OpenAI, for example, says that you retain, and they provide ChatGPT, they say that you retain the ownership of all the input and the output as well. And to the extent that the same is held by OpenAI, they assign it to you, for example, just to encourage users to adopt the use of this technology without having any reservations about whether they'll actually have the rights to what is actually generated, and to mitigate against the risk of being called out or receiving claims against yourself for copyright infringement. Moving away from copyright, perhaps I would just add one or two things about trademarks. We've seen issues of marketing companies relying on AI to create, for example, branding, trademarks, logos, slogans, right? That an AI tool spits out on the basis of data fed into it, and it's somehow aligned with a competitor's branding or things of that nature. You need to be very, very careful in making sure that there's human intervention even as you use some of these tools for creative purposes along these lines, to ensure that no such issues arise from a trademarks perspective. From a patent perspective, perhaps I would just want to say, one of the elements of patent protection is the novelty of the invention. Therefore, when this information perhaps is fed into an AI tool, say, for example, you want to draft claims for a patent and you feed in the disclosure for the patent. Patent standards are quite high, so any disclosures into an AI model for purposes of patent protection would be quite detrimental, right? And another area that I think might be relevant for purposes of disclosures as far as the use of AI tools is concerned is trade secrets, right? Trade secrets may be fed into an AI platform by employees or staff members who are privy to such secrets for purposes of generating their work output. And the question then arises, is such a disclosure then material for purposes of the protection of such trade secrets? While there's, in most countries, no absolute requirement for secrecy, the question or the test that we've seen being applied in many places is that provided the disclosure is not, or rather is obscure, and not all the information is disclosed to those to whom it would be commercially viable, then the secrecy of a trade secret will not be lost if it were to be fed into an AI tool. So the legal risks around that are mitigated to that extent. Now, sort of pivoting, because I feel like I've said a little bit about intellectual property and I need to hear some of the voices on this panel. Taiba, from a South African perspective, we've heard of Dabus, the patent that was granted by the South African Intellectual Property Office in respect of an invention where an AI system was named as the inventor, which is a departure from, I guess, the jurisprudence in a lot of jurisdictions where you require a natural person to be named as an inventor. So basically, what do you see happening in terms of the future of ownership of IP rights and, in respect to AI? What do you see happening in that space? And what can you tell us about what's happening in South Africa as far as AI and IP is concerned, generally?
Yeah, so that was really interesting. And what's more interesting to me is how Davis is going to appear in court to defend and enforce their patent rights in the future. That is still up for consideration, because it's not entirely clear to me how one would establish that jurisdiction. Historically, it's been attached to either juristic or natural persons, and one would say that perhaps AI doesn't necessarily, by virtue of the common law or any sort of interpretation of the law that's been applied to date, doesn't necessarily construe AI. So there's a field in terms of a large focal point in terms of the implications of AI from an intellectual property perspective under South African law. But at the moment, the basis upon which we are sort of operating is that the existing legal framework, for the most part, does continue to allow individuals or to protect their rights. What we hope for is perhaps some updates in the legislation that will allow for a clarity in terms of some of those aspects that you've talked to around copyright and patents even. but perhaps we're a little bit far off from that, because we've just seen a national policy framework that's been issued in this last month in South Africa, and we're probably a way off from actually drafting and implementing legislation that will address some of the complexities of AI.
That's very interesting, Taiba. And perhaps just to pivot slightly from the AI discussion into rather from the IP discussion on AI into the principles that are apply or that are recognized as governing AI. What do you think the role of transparency will play? What do you think the role? What do you think rather would be the role of transparency in revealing the kinds of data that AI is trained on to ensure that there's it's more equitable and representative in its application, especially in light of the risks of discrimination, just to ensure that people's rights are sort of looked at? Because I mean, in terms of one of the most prominent risks that has been spoken about in this discourse generally is, the biases that come into play when AI is deployed, and people being discriminated in very real contexts. What do you think transparency will do, or what is the role of transparency in the deployment of AI?
So yeah, transparency is quite multifaceted in terms of AI. I think Doreen will also know this very, very much in terms of the fact that that construct of transparency is a very sort of well-established one from a data privacy perspective. So the ability to, or the requirement to be able to disclose to a data subject, to a consumer, to a user, what information is being used, how it's being used, for what purpose it's being used, and ultimately, the consequences, the risk of harm in relation to that information. That's the cornerstone of transparency that we've seen emanate out of data protection law. And we're seeing similar constructs coming through in terms of the way that perhaps the EU have now indicated they want to regulate it under the EU AI Act. And we're seeing it in terms of those ethical foundational principles on transparency. What we also know at the moment is that in terms of generative AI, from the point of where it sort of, there's an input from a tokenization perspective to the point that it gets embedded, ultimately decoded, there's a little bit of a black hole, because it's not entirely clear what's happening in that process that ultimately gives you an output. And the difficulty with that is it's not clear to what extent there is already an inherent bias or a discriminatory underlay that is informing the ultimate output. And that is the requirement for transparency, is to be able to understand to what extent the source data is in fact affecting, affecting the nature of the outputs that have implications for people. So from an automated decision-making perspective, there's a huge amount of risk in terms of perhaps the lack of transparency on how those decisions are perhaps made. I was at a Women in Tech event a couple of weeks ago, and they were saying at this particular event that they were trying to find profiles on AI for Black women who were women in tech law, and they couldn't find AI profiles that would match that. And that is indicative, because I mean, there are lots of people who specialize in this area who are, Black women who participate in this field and who haven't necessarily found recognition within the AI. So what we have to be very careful about is making sure that there is a level of transparency to ensure that we don't sort of perpetuate discrimination and bias. The EU AI Act has adopted a risk-based approach in terms of the transparency that they will require on how the algorithms are ultimately used. I think we're some way off, certainly in South Africa, in terms of legislation that will, emulate similar principles. The difficulty being that the source data is constantly, particularly in terms of generative AI, is constantly being updated, and the transparency construct is constantly being challenged in terms of where the biases could suddenly emanate, where they are eradicated and then re-emerge. So you can't have an initial view and then not continue to sample and assess to what extent there are some biases that are being perpetuated. And it's really important from a data privacy perspective to ensure that data subjects are made aware of the way in which their information is being utilized. We saw the writers' strike in Hollywood last year, which the concerns of which were largely attributed to the fact that AI, for example, could, recreate a Quentin Tarantino script. And the ability to then, use that and misuse that is probably problematic for the owners of the copyright, historically, but it's more problematic in terms of data subjects whose personal information is potentially going to be used in contravention of well-established data protection laws without having necessarily established their consent or a legitimate basis in terms of how that processing will be done. So I think there's a long way to go in terms of bedding down all of the necessary transparency requirements and principles, both in law and practice. But it certainly is interesting and great food for thought.
Absolutely, absolutely, and it is a developing space without a doubt. But transparency, I would say, is critical. People, users, the adopters of this technology need to be confident, about, what's happening, once they feed in the information. Otherwise, if there's no transparency, if there's no clarity, certainly the adoption, there would be some resistance towards the adoption of such technologies. And that wouldn't serve the entire AI ecosystem well at all. But just moving on slightly to bring in Doreen into this discussion. From a perspective of new rights, since, for example, the Data Protection Act in Kenya came into play and into force, together with the creation of new rights, for example, the right to access one's own data, the right to erasure and stuff like that. Do you foresee any similar transformation arising out of AI? And if so, what unique challenges, for example, do you foresee arising from the application of the current framework of rights? Could you talk a little bit about rights, the emergence of rights in the space of AI?
Yes, for sure. And I like something that Taiba said
Yeah.
on transparency and the fact that it is very multifaceted. And I think practically we've seen a lot of that. And you see, it's like for data protection as it came in, and then it became widespread, up to the grassroots. You can say that people actually know this is my right as a data subject, protect my personal information. I have a right to access my information. I have a right to transparency, to know exactly what it is you're doing. And you see even what that meant, say, for businesses out here. It meant that we had to relook at what our terms of use say. For example, once upon a time, terms and conditions were very complex things, which, were the preserve of, say, those in legal practice, which, ideally should not be the case. But now we have to really simplify this. So part of transparency is simplicity, because I have to understand what it is you're saying, especially if you're taking advantage of my information, my property, my money, things like that. And that came with data protection. So access to information, how I'm using my information, what do these terms and conditions actually mean? If you're talking of customer journeys, we incorporate that into terms and conditions a lot. Now, how does this change as far as AI is concerned? I would posit that it does not particularly depart from what it is already there. I say it enhances, so that we just need to place a higher standard of care. And the reason I say this is because for data protection, I exist as a human person, and therefore, because I am a human, I have rights. You know, if we go back to the origin of human rights and the Universal Declaration, etc. So just because I exist and I have an identity, then there's the right to have that identity protected. So privacy would be a gateway into all these other rights. It's not the one standalone right. It's, you know, it would affect my right to property if my information was irregularly shared and someone who's a bad player got a hold of it and then, you know, took away, say, my property. So that interferes directly with another right. Again, the right to health, education, etc. All these correlations. So what I would say is for AI, the threshold is a bit higher, especially because of what AI can do. And if we are to relate it to now, again, human persons, I know for generative AI, which is, say, the most common one that we have, we actually are the ones who are unwittingly feeding this AI with a lot of information. We are training it, and you see, we do not necessarily understand exactly what it is doing with it. And again, to tie in with what you said, Shem, how does that affect our rights as holders of, you know, intellectual property and things like that? We've seen interesting cases come up. Even I think in the West, there was the one where two people signed an agreement. I think this was in the US, and to give a voice recording. These are voice actors, and according to them, you see, I'm not sure exactly what the facts are because you see, these are alleged. According to them, what they signed off was for their voice to be used for sort of educative purposes. It was supposed to train something, but then this was put into production by this company, and then you hear your voice as the AI. So say it's a chatbot and it's speaking back. You know, when we speak of IVR and all these things, usually it would be this very automated sort of voices, but then you go and you hear Taiba, it's your voice, Shem, it's your voice, or Daniel, it's your voice. You know, how do you react? What are your rights relative to that? So other than what is there for privacy and you have access to information, you have transparency, I say the threshold is higher. The duty of care definitely is higher, and especially as we move, we graduate the risk. So Gen AI for me is more low to medium level. But then when we're coming to these other elements where we are speaking of high risk AI applications, you know, the ones that actually would have a negative effect on the safety and security of the person, on human rights. Now, you know, and I know in some instances we say even credit scoring. If there's anyone in the audience who's in the banking sector, you know, fintech, financial services, I'm sure they do quite a bit of credit scoring. I mean, on what basis are you giving me a certain level of creditworthiness as opposed to, say, Shem, as opposed to Taiba? And now, if we tie it in with transparency, how much can you disclose to me on why you have given me a particular credit score? You know, so I know if we contextualize it to Kenya, we have the Data Protection Act, which gives some form of, can I say, out for these organizations, and it says give logic, you know, give the logic to the customer. But how will you present that logic in a way that I understand it, but also in a way that enables you to maintain your proprietary right as the developer of that AI? You're the one who created the model for scoring. And I know the models are as many as there are financial institutions. No two models are the same. So those things are usually closely guarded. So what is the balance between what you as the business owner is doing, as the operator is doing, vis-a-vis what I, as the person whose information you're using, what the balance between those two elements? And that's why I say it's sort of, it needs to enhance some of these things. So for example, if we think of credit scoring, because I mean, we have elements of that even in practice within Safaricom, it is not that we will tell you this is the exact formula that is applied, or this is the algorithm, or this is the exact model relied on, but maybe tell you as you engage, as you conduct your transactions on mobile money, keep a lookout for this or on this. So think about the fact that you pay any loans taken on time, for example. you maintain a certain balance within your mobile money wallet. So things like that, which will give you an idea of what the attributes are that are considered in, giving you a certain score. So that balance, the threshold is definitely higher, and that's the challenge. AI is very technical. And how do you explain it in the same way that that person in the village can say, I have a right to have my personal information protected. You have to ask for consent. That is the one legal basis that everyone thinks, should be relied on. So we train them and tell them, no, there are all these other lawful bases. So similar to that, the same way we educated on data protection, how are we willing to go that deep? And that's, for me, the biggest challenge is how far are we going to go to ensure that the people, first of all, who are developing these applications understand what the intersection is between the technical and the legal, and then also the people whose data we're exploiting, because AI relies primarily on data and vast swaths of data for that matter. How then, if it is my data using, if it is organizational data, it need not be personal data, how then do you tell me that this is what you're using, this is what exactly you're doing with what I've given you, so that I'm able to understand that it is not an imbalance of power, so to speak.
No, thanks a lot, Doreen. That's very interesting. You mentioned levels of risk, and you mentioned how, in your view, Gen AI lies in the medium to low strata of risks, and we've seen the EU AI Act, for example, stratifying risks into those three categories: high, medium, and low. So I'm curious, what do you think about how the existing frameworks, um, um, how they currently serve to address the risks that are currently or that exist in the deployment of AI. For example, in data protection, when you're deploying any technology that has got a risk or high risk or likelihood of impacting the fundamental rights and freedoms of data subjects, there's a requirement for impact assessments to be carried out. How sufficient do you think the current frameworks are for addressing some of these risks and mitigating some of these risks that arise in the context of the use and deployment of AI tech?
Okay, I found that quite an interesting question, also because of the fact that, you see, I like to contextualize, especially the subject of AI. And because, the EU AI Act has been passed in an area or in a jurisdiction where a lot has been done in the space of AI, right? So we're not just speaking about Gen AI. They're using recommending tools. And I'm sure there are representatives here from businesses where, you have such recommender tools which are then able to assess what is the characteristic of this customer that makes it possible for us to offer unique, say, propositions to them. So you see, it's able to tailor make, propositions depending on my use of whatever it is that is the service or product that you're offering me, as say we have been able to implement here. So again, levels, and think about how, say, an aviation company would use AI. How would a medical company use AI? So that's why, first of all, there's the stratification of risk. So for the EU, I like some of the things that they did. And I like to think of it for now as a benchmark, but also at arm's length. Why? Again, very developed in that area. I like the fact that they deem some risks unacceptable. So in no way should those risks be should those risks be accepted, things that actually threats, and these are threats to life. If AI is used in a way that, there was talk of, drones that are not manned by human persons, and then see, based on the fact that AI is self-teaching at some point, so that then it's able to make decisions. If those drones deploy, and then you spoke of bias, they target a particular area of people, who do we ascribe the blame to? Who do we hold liable for such things, So I like that some of these risks are unacceptable. Now, for the high risk, now anything which you would deem high risk, and this is considering that we have no legal basis currently that or legislation that governs AI, at least within our context. So some form of governance is necessary, and part of governance is, we take it from a risk-based approach. So I like that we already have, say, data protection impact assessments. I think the EU proposes, in addition to that, a sort of fundamental rights impact assessment, so that you think for these high-risk things, to do with health, I can use AI to assess a case, right? But will I use it to diagnose that person definitively without an actual human doctor intervening? Will I use it to then prescribe medicine? There's some elements that are still missing. So those are high risk elements. If I may pose a general question, rhetorical, of course, would you go into a plane if you knew there was no human pilot and captain? The captain and the first officer is AI, like even a picture of the cockpit is basically an unmanned cockpit, and you're told, this is going to be flown by this tool, and we expect to land in the next, it can tell you all that, but how would you feel? So think about it in that way. That's how you ascribe risk levels. So from a risk management view, the impact assessment, ideally, it's good to borrow from what is already in DPIS. I like that we already look at some of these issues, based transparency, those rights specifically. But as I said, we would need to enhance them because of the unique characteristics of AI. Then, again, think of the fact that in many cases for us, it's not that it's AI we have developed internally. Maybe you're buying a solution from someone in a market where it's already a lot developed. Some of us are in multinationals, something will be adopted in your HQ, maybe in Europe, in the US, and then you're told this is something you need to adopt. What are the things you look for? That is what the impact assessment should do. Is that sufficiently covered within the DPIA? I don't think necessarily it is. So again, an opportunity to enhance. A lot of it is already provided for, like, agreements with these third parties. But in addition to what would be in a data processing agreement, what more should we put in contracts where we are now engaging with someone who's selling us an AI tool to make our lives easier? So things like that. We've spoken about transparency. We now think about the specific principles for ethical and responsible use of AI. We have to think of that a lot because currently there's no legislation. Otherwise, we'd have, a standard to consider. What is ethical and responsible use? Privacy is actually only one. But what we say here, you do not train models on personal information. Aggregate it as much as you can. De-identify information as much as you can. And then on that basis, you still can get outputs which will enable you to make business decisions. But that's just on privacy. We've had the transparency discussion. We speak of safety and security. Now, security also from a cybersecurity point of view. I think a lot more would need to be done by cybersecurity professionals to understand the unique threats that come with AI, right? They will not be the same as what would, go to a conventional, software or system or technology. Now, what are the unique things that would come up and how do we solve for them proactively? Because the point of assessment, you mitigate to low risk, which is now acceptable. So where is the safety and security? And then think of it in terms also of what the impact to society would be. Because again, unique, it's likely to have far-reaching effect, especially high risk. Is that something that we leave in the hands of the people who are developing it? For now, until we get that legislation, unfortunately, the answer is yes. And as I like to say, if there was enough discipline, if we were all rational, we wouldn't need the police, right? Unfortunately, that is not the reality of the world we live in. And that's why you hear talk of regulation. But I think for us, again, contextualizing, whether or not we're in multinationals, it's that we just have to understand where we operate exactly what we have been able to do now. We're talking about homegrown solutions. Have our governments, or the ones who would be the regulators when we get to that point, given us an opportunity to play the field? So let it not be a regulation discussion at this point. Let each institution, each organization, of which I know is the majority represented, its organizations. So put in place some governance, part of which will be these impact assessments that would be a bit more enhanced because of the unique circumstances of AI. Then consider the ethical elements for implementation of AI, what works for your organization, then policies, and finally, and I like to say this so much, awareness, study, train. I don't think we can speak authoritatively on this subject if we do not understand it as much as we can, and not just at surface level. I think we need to also understand it at a deeper level. So a lot of collaboration also between the more, operational teams with the compliance teams, the legal teams. I think that is very necessary. And then it all ties together, and we're able to now move closer to where the EU is, where now they're able to even regulate.
Yeah, that's very, very interesting, Doreen. And when you speak of mitigating risk and risk factors that are at play, then certainly on the other side of that is liability, right? And you've spoken about the ethical and responsible use of AI. And that's very critical. And further pivoting off of what you said in relation to the levels of risk, high, medium, and low, there are certain instances where we have the unethical or irresponsible deployment of high-risk AI tech, and liability becomes a key question when that risk crystallizes. If you've got an autonomous vehicle on a public street driven through AI tech, or the example you've given, the diagnosis of ailments and the prescription of medication through AI tech, when someone drops the ball there, the question then comes to mind, what level of liability should be ascribed to such failures or lapses? Strict liability has been mentioned here and there, but I want to get not just your thoughts, but let me get Daniel's thoughts on this first, because he hasn't got the chance to speak, and I want to hear a litigator's perspective, but I also want to hear what you have to say about this, Doreen. From a strict liability perspective, what do you think, Daniel? Should we be slapping that level of liability where risk of that nature or level crystallizes in the AI ecosystem?
Okay. Applying a strict liability tort regime to AI is like putting AI on a tight leash. It may keep things safe, but it comes with a few bumps in the road. So one of the challenges that applying strict liability regime would pose is the question of who is to blame, because AI systems usually involve a lot of cooks in the kitchen. You have the developers, you have manufacturers, you have the users, you have even data suppliers. So if something goes wrong, who do we point the finger at? It can be a bit of a mess figuring out who's liable when the harm is not straightforward, where you don't know this person did it. Another challenge with applying a strict liability regime is killing innovation or stifling it. Because if developers think they'll get slapped with a lawsuit every time the AI makes a mistake, they might shy away from innovating. This is especially for smaller companies and startups. It can be a barrier to entry, and strict liability could feel like don't even try, because this would seriously slow down progress in fields like healthcare, transportation, where AI is very useful. The other challenge is that AI is unpredictable. So because sometimes even the creators don't fully understand why AI makes certain decisions, especially with AI systems that have machine learning or deep learning. So holding people strictly liable for something they cannot foresee could seem to be a bit unfair. So another challenge would be the high costs because now legal liability means insurance, and insurance means higher costs. Therefore, developers would find they will have to pay maybe higher insurance premiums for high-risk AI applications, and this you wonder who will end up paying for those costs, and it will be the consumer. Therefore, you'll find that AI products will come with a high price. Another issue with strict liability is the causation question, because AI systems don't work in isolation. They rely on external data, human input, real world factors. So pinpointing what exactly caused harm, was it the AI, was it the data, was it the human misuse, could be like trying to solve a puzzle with a lot of missing pieces. Another a major challenge with applying a strict liability regime is the global inconsistency in AI regulation. So you find that AI development and deployment is global. Strict liability regimes can therefore differ from country to country, and this can create challenge for companies operating across borders. So they would have to navigate multiple legal frameworks. This could lead to forum shopping, where parties seek to litigate in jurisdictions with the most favorable liability laws. Yes.
No, that's very interesting. That's very, very interesting. I want to hear what you think, Doreen, on that very same topic. What are your thoughts? You're smiling in a curious manner. I want to hear what you
First of all,
think.
I mean, I definitely agree with Daniel.
Yeah.
I feel like, you see, it all ties back to the fact that we have not explored this to its ends. So, what exactly is it that we are ascribing, liability to? And as he rightly says, then to whom? And I want to see how a court would interpret this, because I want to believe that would be, the result of a judgment. So, what would the court have considered? And would the court have understood exactly how, these models work for it to have arrived at that decision? I think that conversation on especially strict liability is a bit far off. And again, also interesting because of what you said, Taiba, about, awarding of a patent to AI. So what form of person does it take? I mean, is it natural? Is it a legal person? So I'm actually more excited by what that question, the promise of that question in terms of discussions to be had, some legal, some philosophical, to be honest. But what I say is we would need to understand quite a bit about exactly how, the technical elements are operated for us to then be able to make decisions. And then I think also what he said, stifling innovation, it's that we also need to allow some of these things to play out, but in a controlled environment, so to speak. I know that has been done in other jurisdictions where they create sandboxes, for these things to be tested. You like hit it with everything you've got and see, what is worst case, what is best case, and then you amplify best case and keep iterating and things like that. So for now, I think we let people come up with exactly what we can come up with. I think there's a lot more benefit to be had by AI than there is, bad news. So that's what I would say. From a liability point of view, case by case, strict liability, not now. I don't think we're there yet.
Oh, excellent, excellent. I'll come back to you, Taiba, on the issue of regulatory trends. What trends do you see emerging, in dealing with this? There's so much that can be said, lots of use cases, lots of deployment scenarios, lots of possible risks. What do you see, if you were to look into your crystal ball, what do you see as the emerging trends as far as the regulation of this sort of technology is concerned? We've seen the EU coming up with an AI Act. Do you think, Africa and the rest of the world perhaps might follow suit? or do you think a more context, cultural specific angle will be taken towards regulating AI in different jurisdictions? Taiba, you're on mute.
That's a constant problem. I was saying I wasn't psychic in my spare time. Yeah, it's, the EU probably had data protection legislation, I think, which they would have the first version of the directive in 1995, and I won't say where I was at that point in my life, but and it took many, many, many years, before you started to see a more ubiquitous rollout of data protection legislation. And at present, you don't really have the equivalent of data protection legislation as sophisticated as GDPR. Even POPIA in South Africa is fairly new legislation. So I'm sort of a little bit more cynical. I think it's going to be a long time before we see, a full sophisticated regulatory landscape. And part of the reason why I'm a bit more cynical about it is because the nature of AI and the way that it's already being rolled out. So we've got sort of investment sort of in the region of about about $5 billion odd dollars into AI technologies that basically allow for varying degrees of, so they've been used in the agricultural space already across Africa. It's been used, in terms of that investment, you're going to see an acceleration of the utilization of AI, you're going to see the consequences of the AI before you're going to see the regulation come. And that's not unusual. I think what's more important in terms of managing your risk associated, that certainly what we're doing from CDH perspective is to Doreen's point, supporting our clients in terms of creating that level of awareness, the utilization of AI within businesses, what's appropriate, what's not appropriate, what are the ethical guidelines that you can be prescriptive about as an employer to your employees, how to manage your proprietary interests. We saw, quite a few years ago, Samsung's proprietary code being put onto, generative AI. So trying to create a format for guidelines, trying to create awareness, and then more importantly, what you will see is data monetization strategies, which we are supporting clients with, and trying to support that sort of contractual framework. It's more likely that that's where you will see the most development in the short term, is how you're going to contractually address AI in terms of sampling, in terms of managing those databases, in terms of managing the effects of automated decision making. And I always feel like the most likely landscape or legal landscape where you will see something is the employment landscape, because a lot of the sort of AI tools that are driven around, decision making for recruitment, that are emanating out of Europe and other places in the world are hugely contentious. More likely to see a labor court case before you see, other types of jurisprudence. Certainly there will be a need, I think, for intellectual property to be addressed in some shape or form in some jurisdictions eventually. But I also find that in South Africa that sometimes is law that the courts grapple with before the legislators do. So an interesting landscape, I think, for the future for lawyers. No regulation, I believe, in the very short term. Some prohibition, definitely in some territories. I think there was a study that Lloyd's Foundation did a couple of years ago, and we are still hugely cynical in Africa about the implementation of AI across the continent. And so there is a certain degree of optimism, but there is also cynicism. And some of that cynicism in more sort of conservative jurisdictions likely to lead to some degree of prohibition. Certainly what we wouldn't advocate for that, but I think you will also see that once the impact of it. The other thing that will also affect the nature of regulation is that South Africa is and Kenya perhaps in slightly different spheres, but we are still bridging the digital divide across much of Africa. And without bridging that digital divide, you won't get the full wealth of benefit, across the board for AI for the populace. And so that's probably going to influence how easy or how difficult it is to get access to AI-driven technologies over time.
No, thank you very much for that insight, Taiba. I tend to think as well that while it's very, very difficult to state with any level of certainty what form the regulations that we will put in place ultimately will take, certain things are likely to be incorporated, like a risk-based approach to AI regulation, alignment with core principles of AI, transparency, sustainability, accountability, and the like. There might be some sector specific rules. It's possible that you might have the telecommunications regulator saying, listen, for purposes of players and licensees within this sector, these are the guidelines for the deployment of AI. Perhaps you might see, policy, digital policy areas being regulated separately, say, for example, cybersecurity or data privacy or IP. The use of sandboxes has been common in some jurisdictions. So I think some of these things might be replicated, but, don't hold me to it. It might or might not be the case. I just want to move maybe to some questions because I see, quite short on time. And I want to sort of read one of the questions that has been sent in by rather from our audience. And one listener asks, and perhaps Taiba, you could take this. If you remove personal information when using generative AI, but continue to enter a particular set of facts which are unique to the client or merger or matter, do you need consent to process the information through Gen AI? Do you need to make your clients or your employer aware that you're using Gen AI? Do you need consent? It's a loaded question, but if you could just speak to that quite briefly, that would be great.
You're on mute, Taiba.
Sorry, this is a constant problem. Apologies. Really, thanks for the question. So just to give you a bit of insight, in terms of the guidelines that we advocate is that, every input that you put into, any generative AI platform requires you to apply your mind. And, there's not one set of rules in terms of whether you need consent or you don't. Often there's a backdrop of confidentiality outside of the parameters of personal information. Is a backdrop of confidentiality that is owed between the parties. But you be very careful about, inserting information into a platform that is strictly speaking confidential information, which you otherwise wouldn't have, been able to disclose. So if you can't disclose, if you can't say this or speak to someone outside of, a cohort of clients or whatever in relation to the information and the facts or the content that you're putting onto the generative AI platform, then I'd say you're probably not well placed to actually put that onto the platform in the first place, because but you'll have to look at it on a case-by-case basis. The second thing that's really important for us to bear in mind is that from a legal perspective, once we've popped something into AI and we've generated content, we don't necessarily have legal privilege attached to that content that's actually been generated off an AI platform, which means that what we were maintaining in terms of professional privilege would, strictly speaking, be possibly subject to disclosure in terms of a discovery in court, which is what you don't want. So every time you're using your AI, it's an application of your mind in terms of guidelines around what are your confidentiality obligations. Are you maintaining those confidentiality obligations? Is some of this information generically in the public domain in some shape or form? And can you pseudonymize or anonymize the information in terms of which you would continue to protect the confidentiality, continue to address or restrict the processing of personal information? If you're assured and you've approached it with appropriate level of diligence, then certainly use the platform. But it's a case by case. It's not a rule-based approach. Hope you've answered your question.
Indeed. Thanks a lot, Taiba. And we appear to have run out of time, unfortunately. But I'd like to thank you, Doreen, for your insights, invaluable insights. Thank you so much, Taiba, for joining us as well. Thank you, Daniel. Your contributions have been invaluable. I'm sure the audience has benefited to a great degree. I certainly have also learned quite a bit from the erudite speakers on this panel. Thank you sincerely to everyone who attended the webinar as well. We trust that you've gleaned some insights into this ongoing discourse on AI, and we'll keep talking about this. We'll keep discussing new talking points on subsequent webinars, podcasts, and other content that will be available on our website. I believe this webinar will also be available on our website in the coming days. And on that note, thank you very much for attending, and do have a very pleasant morning.